I think I'll follow the lead of having 4 points. I never do uneven numbers. If I do anything in uneven numbers, there's a real danger that the world will tilt on its axis in a dangerous way and get out of harmony. So, it's a joke amongst my students that I will say, there are 4 points, or there are 6 points, or there are 8 points, but there are never 5 or 7.
And there's the bottom line.
And there's always a bottom line. Okay. But this time there's a prologue to the 4 points. So having just written a piece which involves me delving into a wonderful Shakespearean quotation, of course one of the best ones, and best known one, is from Henry VI, Part 1, where Jack Cade says, the first thing we do is kill all the lawyers. Probably not a good idea, but that's one way of looking at the future of the European judicial system. Get rid of all the lawyers, you probably wouldn't need courts. Okay, on a serious note, 4 points. One is that, and some of these echo and round out some of the things that the Advocate General was just saying. One is that I think at the judicial level, as well as at the political level, member states we need to be clear about why decisions are made and who's pulling the strings. And that I think one of the constant malaises of that besets the EU as a whole is that the EU is often blamed as an institution for the imposition of a decision on the assumption that it's imposing the decision in a top-down sense. Brussels is dictating something. In reality, in circumstances where, in fact, it's the member states who are calling the shots. And that's true politically because the reality is that the member states shaped and were the principal players with every single treaty change and amendment from the Rome Treaty onwards. It's the member states who shaped the architecture of the decision-making that we have. They shaped the architecture for judicial decision-making. And if you're looking at the future of the courts, and the real danger in the EU is that the member states keep shaping the decision-making, but don't accept it when things go wrong and keep offloading responsibility onto the EU. I mean, it's a classic thing that political scientists will tell you is rational state action, using the word rational in a very, very limited sense of the term. But, they'd say, well, take the benefits, don't take the burdens. So if things go well, you claim you did it. And if things go badly, you claim they did it. But the trouble is, all of that has costs in the long term, if not in the short term. But so really, we see that this manifest in some of the reforms for the judicial institutions. Because, I followed all that process quite carefully, and it was quite clear that, to me, looking at all the documentation, that the General Court certainly needed extra judges. It didn't need extra judges, but it certainly needed extra judges to cope with the increased workload. And there are various rather sensible options on the table about how many judges you could have, lower than 28, and how you would allocate them amongst different countries. And they were, pretty sensible. It wasn't rocket science. It wasn't that difficult to do. But the bottom line was, as you said, in effect, every state's a veto player. They all say, well, no, we want our own judge. We want our own judge. We want our own judge, and we won't accept anything less than 28, which is just objectively crazy. Because you don't need another 28, you probably need another 10 or 12 or something of that nature. But you certainly didn't need 28, and as we all know as lawyers, the very notion that they're your judge is ridiculous anyway, because they really are not deciding from a national interest. They really are representing a European interest. So my first point then is that much of the malaise which affects the EU as a whole, with member states making decisions from their own vested interests and then blaming the EU for the consequence can also affect the judicial institutions of the EU too, and that includes reform of the courts. My second point is concerning, is a related one, and it concerns much of the literature about activism on the court and the way in which the court has allegedly been a party to competence creep and has increased the scope of EU power, etc. Now, there are two dimensions to this, two brief dimensions to this point. The first dimension is the following. The reality in terms of competence that the EU has is that the scope of EU competence that we presently have, that the EU presently have, is affected by three major variables. One, what do the member states agree to in terms of allocations of new competencies when a treaty amendment has occurred? Secondly, what legislation is passed at EU level in order to flesh out the treaty articles? And third, its court decisions. Now, I'm not going to attempt any estimation about which of those is most important, but all three are important. But what's clear is the first two are just as important as number three, and in my view, actually, they're considerably more important. The reason why you have a chapter on the environment is the member states voted a chapter on the environment. The reason why you have a chapter on of the kind that we have on social policy is that the member states voted to put it in, etc., etc. Equally with EU legislation, what EU legislation is passed is, of course, at the behest of the Commission, but it also has to go through the through both the European Parliament and the Council. Member state interests are perfectly well defended in both instances. So the idea that wherever we are in terms of the competence of the EU is all down to a court which is out of control seems to be a ridiculous statement to make. That doesn't mean that there may not be particular court decisions which are controversial. We all know there are. There are inevitably court decisions which are controversial and which, where you think they're pushing the line between teleology and text a little too far. But hey, we could probably say that in most of our cases about national courts as well. So that brings me on to my third point, which is, again, there's an asymmetry in the way that we look at courts, at least some of the time. And I think that asymmetry is best demonstrated through an example, a very brief example, which is one which always makes me chuckle, and which involves the Bundeswehrverfassungsgericht. So the Bundeswehrverfassungsgericht has, of course, as we know, been one of the most prominent critics of the ECJ, trying to keep it in line, etc. One of the most prominent critics of excessive activism by the ECJ, etc. And you see this line coming out again in the Lisbon judgment, the Lisbon Treaty judgment, which is a wonderful case in all sorts of ways. But the point that I want to emphasize is this. The Bundeswehrverfassungsgericht is many things, it has many smart judges. Self-irony is not, or paradox is not one of its strong virtues, or the realization of paradox is not one of its strong virtues. And there was a paradox here. Why? On the one hand, in the Lisbon judgment, it was again pushing this critique of the court, saying, you be careful that you're not excessively activist in your interpretation of EU law. At the same time, what was it doing in that judgment? It was announcing a new form of lock, identity locks, okay? And the most prominent commentary from German academics about that judgment was to say, excuse me, it's very interesting, but where did you get this idea of identity locks from? where did you get this idea that German national identity is constituted by these 5 elements which they put in their judgment? So my point was that the national courts, again, and the UK Supreme Court's done a bit of this too, they're fond of criticising the ECJ, saying be careful about crossing the line between interpretation and treaty amendment and all that. At the same time, in their own backyard, when they're interpreting their constitution, they're making unbelievably far-reaching judgments where the people who know about their own constitutions look at those judgments and say, well, this is very interesting, but we're not sure where you found this stuff at all. My 4th and final point is concerned with judicial dialogue. And I think judicial dialogue is important. It's one of those things that we talk about as informing 267. It's important, and it is a two-way street. And there has to be some give and take on both sides. There has to be give and take from the national court, and there has to be give and take from the European court. And the truth to tell, neither of them get it right all the time. And again, that's not surprising, because courts are imperfect institutions, like all institutions. They're imperfect. So I can think of instances where I think the stance of the ECJ was too rigid, and I can think of and not open to sufficient dialogue or discourse. I can equally think of instances where the approach from the national court was unduly aggressive. I mean, I think the approach from the Bundesverfassungsgericht in Gauweiler was pretty aggressive in the reference that it made. I think in that instance, the European Court of Justice was quite mild, did not react to the tone of the reference. I think equally the response of the German court to the Gauweiler decision by the ECJ, the response by the Bundesverfassungsgericht given recently, exhibits there's a wonderful duality in terms of discourse. On the one hand, accepting the decision of the ECJ, saying, no, we won't go to a nuclear strike situation here. On the other hand, once it said, yes, we're willing to accept the ultimate result, then reverting to its previous more pit bull terrier kind of aggression, and actually, towards the end of the opinion, there's some really pretty harsh words from the Bundesverfassungsgericht about the reasoning of the ECJ, which I think on substance are not justified. So I think discourse and dialogue, it's difficult to pin down, but it's got to be there under 267, and there has to be a two-way respect. And neither institution always gets it right, but it's something that we have to continually work on. Thank you.